Hello, everyone. This is Chapter 2 Ethics and Other Professional Responsibilities for Human Service Workers for Counseling 4000. All right, let's do an introduction of this chapter, which is that workers who do not practice within ethical parameters cannot be called professionals. So, parameters is kind of like the boundaries of, okay? Understand their ethical obligations and seek guidance when they do not. So one of the hints that it's talking about is the fact that you do need to know the ethical expectations of your field, okay? And when you realize that you do not, you need to be able to go seek out the answers to those things. Playing dumb, playing ignorant is not going to make it in this field, okay? And we'll talk about the legal consequences because of that. Created to protect vulnerable people, which is typically known as your clients. Prevent exploitation, basically taking advantage of people who come for services. Ethical codes of conduct protect the professional as well. So it's really going to protect you as well as your client, okay? Those who follow their codes of ethics carefully are not likely to get into unethical or illegal situations that could result in losing a job or judged legally liable to harm caused to the client. Okay, so what that is saying is if you are aware of what your ethical responsibilities are and you follow it, most likely you're not going to be able to really get in trouble because you have been consulting the code of ethics and you are operating along with it. Failure to know or follow these guidelines can result in a dismissal from an agency, which is also known as being fired, and then civil suit that proves that you were in a violation that caused damage to the client. So that would be if someone decides to sue you and you are found guilty, then that could also happen as well. Okay, let's talk a little bit about the broader ethical concept. So let's talk about the big picture when it comes to ethics, which is that there are three perspectives. There is the moral, ethical, and legal. Our responsibility is to respect and follow these codes of ethics. You will need to choose the right action in the areas that are gray, also known as not clear, right? So some of the times your situation is very unique. We're expecting you to look at the code of ethics and see how it could be applied to that situation, okay? Then you can talk to your supervisor about it. You can review the code of ethics and then also consult a lawyer to understand the specific laws if it's a legal issue. So let's actually go into these definitions specifically of these three perspectives. The moral is related to culture and socialization. So what we feel is right within our area where we live, which is pretty much America, right? And it could be state specific as well. And then what we feel is right, what we have been socialized to view as morally correct or right. And it can be tied to religion as well, right? So it really does depend on the situation. Then there's ethical. Ethical codes are created as guidelines for behaviors of members in a profession. So typically what we do is we look at or consult the ACA, the American Counseling Association, for our field. Required by everyone in that profession, so everyone who is a trained professional should be very aware of the ACA's code of ethics. Suspension and loss of privilege, such as no longer working in the field, can be a result if you do not follow the ethical codes. There's also the legal, which is considered the law component. Typically more unethical, but not always. Sometimes governments also decide what is legal and illegal behaviors. So you might need to go to a court to decide how that's going to come out. All right, now let's talk a little bit about dual relationships. When you and your client have more than one relationship. So for example, let's say that you're the case manager, but you're also your client's cousin. Or her boyfriend, let's say, her customer at a beauty salon, her teacher. It could be multiple things, right? But it could be someone where you talk to that other person on a regular basis outside of case management. So again, that becomes an issue, and we're going to talk a little bit about what happens when that happens. So conflict of interest. So what that basically means is that you are trying to help your client, but maybe there's something else that is making you or influencing you to make a decision for another perspective. Okay. So number one rule is to avoid all dual relationships when possible. For example, you are going to attend an event and your salon person cancels on you, right? So you want to get your hair done, but they canceled and you're really desperate. for looking for another person to help you with that. So your client is a hairstylist and is willing to connect you with a salon for an appointment. So they might not necessarily do the actual hairstyling for you, but they kind of did you a favor, right? So let's explore what happens. So months later, your client needs a prescription filled out by her psychiatrist who is out for the week and cannot be reached. She wants you to call the pharmacy and approve the refill. Okay? You feel uncomfortable about this. She says that she did you a favor with a salon and this should not be an issue with the refill, because let's say she says, I get the refill all the time, right? And then she might say, I thought we were friends. So either decisions that you're going to do are going to be probably problematic. You can call in the refill, which means that you have broken agency rules about medical approval requirements. But if you do not call in the refill, now your client no longer trusts your agency because they thought that there was a give and take relationship, which was not necessarily what was a smart idea at the beginning, right? So again, if you do have problems and your client offers additional help or whatever, typically it's polite to say, thank you for the offer. Let me get back to you, right? And then just go on and do something that's not related to your client. This way, you're not going to have a conflict of interest, which will make you feel very anxious about what is going to happen, like in this situation. All right, dual relationships exceptions. So sometimes there are exceptions. And the most common one that you'll hear about is for small rural communities, basically small farm areas or very, very small cities that are rural. Okay, it is not possible to avoid dual relationships entirely because let's say if everyone goes to church and there's only one church in the city or in the town, then you're probably going to see each other in church as well as in therapy, right? Or as a caseworker. You can make arrangements with your client about possible problems that may happen and how they can avoid these problems from both sides. If you both can come to an agreement, that's fantastic. But if one cannot, then discontinue services, and then maybe if there's a possible referral or something like that, you will do that. So here's a really quick example of something that I would tell my client, even in a big city, which is if I see you at the mall, right? I'm not going to acknowledge you, but because I want to protect your privacy, right? But if you want to come over and say hi to me, totally fine. I'll probably say hi to you, but I won't talk to you a lot because some people in the community know that I'm a therapist, let's say, or a caseworker, right? So if you talk to me, they might think that you are also a client of mine or something like that, which means that we have broken confidentiality and I want to respect your privacy. Okay, it's not because I'm ignoring you on purpose or anything like that, in a way where I hate you or I'm embarrassed by you or anything like that. I just want to make sure that you are protected and respected, and your privacy is also, acknowledged that way. Okay, and then you will both agree that. Okay, and then that way no one will be hurt, and then you would probably revisit each other next time you see each other in a professional setting. Just check, make sure everything is going good. All right, let's talk about gifts from people you serve. Not a dual relationship, but it is a conflict of interest because of what that gift could represent. So best is to avoid accepting gifts so that you can keep it professional. Gifts are potential ways of manipulating the situation. So for example, you might hear someone say, I'll give you this item and you accept it. Next time you owe me something, right? Your clients could think that. Or they might say, I gave you that gift and you are not helping me. You're not siding with me about the situation. I thought I was right and you should think I was right too. Or I gave you something because I am a nice person, so why would you say no to me, right? Again, there's that manipulation that happens. So maybe gifts when it comes to at the end of termination, at the end of the relationship, we'll talk about that in the next slide. A client is grateful for all the help you've given him while he was looking for work. He was able to find a job at a garden nursery, and once he was able to pass probation at work, he wanted to give you a plan to show appreciation. For this, you can accept it because it may be a cultural reason behind it. Let's say if that person has a specific culture or ethnicity that you are aware of, and it was a big part of who they are. If you refuse the gift, the client may feel like you're rejecting them. Say that you want to keep the plant at the office for everyone as opposed to taking it home. And when the client offers a gift, document it in their files. What was it? Was it accepted or rejected, and why? So here is one that I have actually used when I was working with clients who've offered me gifts. Okay, I'm like, oh, thank you for the box of chocolates. At our agency, we're not allowed to accept personal gifts. However, I know how proud you are of reaching your goals. You are thoughtful for getting these candies for me. If I accept them, is it all right if I share it with the entire staff so they also know that they were doing a good job providing services to our clients? So you can sort of see how that becomes more neutralized. It becomes an agency, right? But typically, if you just don't want to accept any gifts, you can just say our agency forbids us from receiving any gifts. But thank you so much. If you want to, you can write me a card and I would gladly accept that. But gifts that are, more than like $1 would be considered unethical at our agency. Okay, you can say something like that and they should not be able to be hurt. But again, it becomes a context of the situation, the culture, and stuff like that. Okay, now let's talk about sexual or romantic relationships. It is not uncommon for a client to fall in love with their caseworkers. The worker is kind and helpful, which may be seen as love and affection. So if you think about a client who's been abused, and then now they're seeing someone who's thoughtful, listening to them, and caring and worried about them and showing empathy, they might potentially develop a crush on you, okay? Sometimes a caseworker is the one who's overwhelmed at work and the client talks to them like a hero. So now this is the other way around, which is that the client is helping make the caseworker, or let's say the counselor, feel better because they're having a horrible day or time. The caseworker may fall in love with their client because they offer recognition of their hard work. So it goes both ways. Either way, do not have sexual relationships with your other person. The person responsible for maintaining a professional relationship, regardless of the personal feelings, is the case manager. So both situations that we just explored, it's still the case manager or the counselor's responsibility. They are the one in charge, okay? They will have to take fault if it is going to happen or anything happens. You have to maintain appropriate boundaries. Your client is always assumed to be the vulnerable party, okay? Remember that. Look at the Figure 2.1 warning signs that the worker-client relationship may become too personal. So most states against the law to engage in sexual or romantic relationships with the person receiving services from you. Okay, so it's illegal. Also, you need to see your code of ethics in your field to see how long after termination it is allowed. So what that is saying is after a certain amount of years, and you've stopped being, like, let's say, caseworker and client or therapist and client, then you can start dating your client. Typically, it's 5 to 7 years afterwards, okay? I'm going to just recommend that you just don't even do it, okay? There are plenty of fish in the sea, I think, for you. All right, let's talk about boundaries. Code of Ethics defines boundaries to protect the clients and the workers. HIPAA sets boundaries for a client's information, which it can be released, and what the safeguards must be in place. So boundary crossing is in group sessions. A caseworker wants a group perspective in a personal problem. You want your daughter to be friends with your client's daughter, or you lend your client something and they show up to your house to return it. So they've crossed certain boundaries when it comes to being a professional relationship, right? Like, you are no longer just a client and the caseworker. Your kids are friends now, right? Or you lent them something and now they know where you live and they're going to come to your house and return it. What happens if they keep on coming back to your house to visit for some reason? Or when they need more stuff, are they going to come back and visit? That becomes an issue. So the boundaries have been crossed. So in small rural communities, again, we're going to revisit that idea. Let's say that you're a tutor at an after-school program and your client is one of the participants in the tutoring, right? So you do not bring up to everyone that this person is a client of yours unless a client decides to reveal it themselves. So you want to leave it up to the client to reveal whether or not they go to therapy or they have a caseworker for a specific problem. But when this does happen, we want you to also still keep it low key, right? Do not share any problems that your client is going through or your case client is going through at all. You know, if they acknowledge it, then you acknowledge it, but then that's it. Don't explore and go further with all the other students or kids that are looking for help, so that they know what your client personal problems are. All right, cultural communities. Some populations have closer relationships with their workers. So maybe it is an indigenous group or a collectivist type community. They might have closer relationships because of that. Other examples would be, let's say, women's programs and substance abuse programs. Sharing common problems is not unusual because typically some of those people who are working with those populations have lived experience themselves. So the relationships might be a little bit more equal, right, compared to other times where there's more a higher power dynamic. But remember, there is still a power dynamic in this. So we're expecting you to behave in the professional way that we expect you from our code of ethics and the profession. Now let's talk about value conflicts. Your values and your client's values are not usually why the client is coming in for services. But sometimes there's religious, moral, and political values that play a pivotal role in the problems to the agency. So here, I think a very common one is in today's world, in today's politics, is whether or not you are Republican or Democratic, right? So first, know who you are and your feelings about certain issues. So you should be aware of those things. If there is a value conflict that will interfere with services, you can discuss it with them. So if there's a major thing that's really showing, talk about it, right? But typically, I would say that the counselor is going to stay neutral on everything. Okay. Second, if a severe conflict exists, maybe transfer them to another case manager when you can no longer be objective or you don't feel extremely comfortable anymore, or compelled to impose your own values on this other person. Then it's time for you to remove yourself from the situation and refer them to another person. Okay, so again, we talk about politics quite a bit. Religion is another one that's going to play a huge one. You all need to be comfortable, but also look at why they came in here for services. Was it a political reason? If it isn't, I'm hoping that everyone can still work with each other still. Whenever possible, avoid discussions with your client about political views or affiliations. People are likely to feel alienated by people with different political views and may want to argue. Typically, the reason why they are seeking help is usually not political, right? So when you identify yourselves in a specific way, people might feel uncomfortable, right? So what was the purpose of that, right? So again, think about the client as the most important person in the situation, and why are they here looking for help, right? All right, rights of individuals receiving services. So as a client, well, let's talk a little bit about what their rights are. Okay, clients have rights when they seek help. Some professionals will fail to inform clients of their rights because it is easier to work with people who are vulnerable and uninformed. So you should not do that. You should always have a client who is informed. Okay, and we'll talk about that as we go through the rest of this chapter. Informed consent is to give them an opportunity to become an active participant in decisions that affect them. Okay, remember, we want them to make the decisions of who or where they want to go because it's their lives, right? Once you are done with them, it's no longer, you're no longer that part of that person anymore, and they have to keep on living their lives, right? All right, even if involuntarily committed to inpatient care, which basically means that they did not choose to go there, they were placed there because of other people, they still have the right to refuse treatment to the extent permitted by their state laws. They have a right to not be transferred to another facility without clear explanation. Informed if possessions are removed, right to handle personal affairs, and then, of course, right to practice their religion. Right to express concerns as well. If they are unsatisfied with their caseworker, they should be able to share that. And if they're unhappy with a treatment plan, they should also be able to voice that as well. Right to self-determination. So this one is basically right to make their decisions, right? So the right to do research about the diagnosis once they find out what it is, a right to question the treatment plan and to make suggestions, right to withdraw from treatments and services, and right to choose their own goals. Okay, so again, we're talking about empowering these people. And in America, if you are an adult, you really do have a lot of freedoms. Okay, exception is when an involuntary court commitment. So again, if they are put there for safety reasons, then these things might be a little bit different at that moment. Okay, learn to let people make mistakes and learn from those mistakes, and that's one thing that you do need to let them do. You have to sometimes stand back, even though you've been working with them, and let them make these mistakes. Hopefully typically they're safety, it's not like a life or death type of decision, and let them learn from what what mistakes they have made. Some learn that they're not as ready as they think they are for basically growth and change. So it's also make them realize, where they are. Because sometimes people think that they're at, a higher level than they are. And we need them to realize it, right? Without us saying it so explicitly sometimes. Okay, let's talk about informed consent. Informed consent is when a person is informed and gives consent to treatment. So typically before you start any type of counseling or case management, you want to start with an intake. And during that intake, you talk about the fact that they have all these rights, okay? And they need to agree to them as well. So agency policies are explained and choices of treatment are outlined. Let's talk about any side effects. So that could be adverse effects, which means like severe, or negative consequences that could occur as a result of treatment, medications, or procedures. So it's about being grounded, being realistic, okay? So a person is coming in for therapy or for services. Sometimes they don't get what their final goal is, okay? One reason or another, something is preventing it from happening. And we want to be realistic and say 100%, it cannot be perfect, right? Any risk that might occur if the person elects not to follow through for that one is, let's say they're going to therapy for 2 months, and then after 2 months they decide to stop, right? So when they stop, obviously they're not necessarily going to reach their goals. Okay, what is being offered to the client, such as treatment, what will be included, and any risks or benefits. So let's say if this is therapy, you might tell them a little bit about the type of therapy that you do, right? And then from there, this is the kind of activities that we might have you do. It might make you do some journaling or something like that, and how it could be helpful or it might not be helpful. And then any alternate procedure that are available. So if it doesn't work one way, we can try another way, or we can also do a referral to someone else who might approach it differently. All of these three must be present to say that they have given informed consent, okay? The capacity. So we need to make sure that they have the ability to make a clear, competent decision on their own behalf, which basically means that can they think, in a typical way, and they can actually make a decision like to say yes to therapy or no. 2, comprehension of information. Person clearly understands what is being told to them. So as you're talking to them, you need to feel it out and see whether or not they understand what's going on. 3 is voluntariness, which is a person gives their consent freely with no coercion or pressure, so that they want to do this on their own. No one is forcing them to do this, okay? Let's talk about confidentiality. It's an ethical principle and legal right to know that what the client is sharing in the office will remain confidential. So that means whatever is said in this office will stay in this office, typically. Minimum necessary rule is releasing only what other agency needs to know to work productively with the client. So now we're going to start to talk a little bit about the terms of paperwork and stuff like that. The client has the final decision typically. So if they want to release their information to another agency or whatever, they have to fill out forms that you'll provide for them. And then from there, you can release it. But when you release it, you don't release all of your files, just what is being requested. Okay, so if it's a specific medical thing or a specific goal, just do that. You don't have to present everything to the other person. Release of information form. Historically, they would sign a blanket permission statement that would allow information to be shared with others that the agency would saw fit. So a blanket permission statement is kind of like a broad statement. So sign this form and we will release this information to anyone who we think needs to know. right? But today it must be a lot more specific. It must be stated specifically to whom the information is being released and must be time limited, 3 months, a year. It depends on the situation. So the textbook is advising, and I advise to you as well, do not use forms that ignore this type of more modern specific form. Okay. Age guidelines varies with states. In terms of addiction, anyone can go for addictions counseling or receive services for addiction. For mental health services, for some places it's 14. However, in California, it is 12 and older, if the professional believes that they're able to understand what is going on. So that is the client themselves. Okay. Release of information regarding HIV and AIDS requires permission from the client. So that means that if they do not sign a release form for HIV/AIDS, you will need to delete that from the records, and even delete records mentioning them taking HIV tests and the results were negative. Okay, this is if they have not signed an HIV/AIDS release form. It is a specific form for that specific situation only. So if they're requesting other information be released, and they are HIV positive, right? And there's mention of HIV, you have to go into those documents that are being released, that's okay to be released, and delete all the stuff that talks about HIV. COVID cannot release information about your client being vaccinated or not, or if the client has had COVID. However, we can ask if they have had COVID or have been vaccinated. But if they have not released any of that information, then we are not allowed to release it and send it out. They have to also sign permission for that as well. Collegial sharing. So basically that means is with your coworkers, your colleagues, okay? Ask permission before sharing information with your colleagues. Student interns are usually not allowed to read anything before they have signed a pledge of confidentiality. So they might have to go through HIPAA training and stuff like that before they're able to release that. So for those who are going to do an internship, let's say, and they need to, let's say, read through paperwork, make sure that you will have the opportunity to. Some places, the supervisor will not let you read any information. So if that happens, at your internship, you might not get that much of an experience out of it. Okay. Other places will allow you to read the paperwork. So again, that's a question you should ask when you are going into your internship phase. All right, guarding confidentiality on the phone and in other conversations. So here is a script. You, hello. The caller says, hi, this is Ann Taylor. I'm a counselor at Marlboro Middle School, and I'm calling about Ari Smith. Did he and his mother keep their appointment with you today? And then you might say something like, I'm sorry, I can't help you with that. Would you have Mrs. Smith sign a release of information form stating what it is that you need to know? And if Ari Smith is known to us, we can send the information to you. Okay. In this situation, you do not give any hint that the client is known to your agency. By saying it is a person, if this person is known to us, you avoid letting on whether the client is or is not known to you. Okay, so here we do not even acknowledge that they're a client of ours because that would break confidentiality. And also, we don't really know who this person is. It's on the phone, right? Or even in an email or something like that. You do not reveal any of that type of information. Your client should let us know, or let the agency know, or you know, what is going to happen. Like, oh, expect a phone call from this person, and then you understand. But even during that time period, they need to sign a release form for you to acknowledge any of that type of stuff. Here in this conversation, we're putting it back on that person to do and accomplish the information request. So when can you break confidentiality? Number one, when you must warn and protect others from possible harm actions by the client. You or your agency must warn another party if your client is intent on harming another person or group. You should also notify the police. Okay, that makes sense, right? If there's harming other people. Number two, when the person needs professional services, if a client overdoses on medication and is in the emergency room, the ER may call about prescriptions of the client that was being taken so that the proper medication this time around will not, clash with that and then potentially hurt them even more, right? We need to know what kind of medication they're on so we understand what kind of medication we should not give that person. 3, when you must protect people from harming themselves, people who are threatened to overdose or commit suicide, you might have to then report them, call a triage team or the police. 4, when you're attempting to obtain payment for services and the payment has not been made, your agency report non-payment after reasonable attempts have been made to remind the client of due payment. So this one is saying is you tried a bunch of times to get the client to pay and they're not paying, so now there's going to be a lawsuit involved, and that means that you're going to have to say that this person received services from us and they're not paying. Okay, but you have to do it a couple of times where you remind them. So when they permanently are refusing to pay is when you can then now start to bring this up. Okay. Number 5, when obtaining a professional consultation from your supervisor regarding how best to proceed from a case in supervision. So that means you're talking about it with your supervisor. So that is talking about it, right? But it is, again, a professional place where you are able to share those things. And you let your client know about these things beforehand. Okay, diagnostic labeling. Rely on diagnosis in order to be paid for services by a third-party payer. So that basically means as you see your client, but then you got to bill them too, right? So typically they have, let's say, insurance, then you would have to bill the insurance and you have to let them know, the insurance company know what's going on in the sense of, a diagnosis or whatever it is. It also could be Medicare or Medicaid that you're going to have to reveal these things too. So these are payment reasons why, right? Okay, so here's the thing. For some people, they don't want their insurance of their workplace, let's say, know why they're going to therapy or receiving services. So some people may not want their insurance to know, and so they may pay out of pocket. So they're just going to pay cash or whatever from themselves instead. Privacy, the freedom of individuals to choose for themselves the time and the circumstances under which and the extent to which their beliefs, behaviors, and opinions are to be shared. So they are choosing to not tell people or to tell people. They have that right. The right of a person to choose what others may know about them and under what circumstances. And the condition of being free from unauthorized observations or intrusions. So typically people are allowed to keep their information secret or private if they want to. Okay, let's talk about Health Insurance Portability and Accountability Act, also known as HIPAA. This was created in 1996 to ensure that people did not lose medical coverage when they changed jobs. So remember, back in the olden days, in the 90s, before most of you were born, we did not have emails, really. We did not have text messages. We did not have all that stuff. So things were being sent either through mail or through this thing called a fax machine. So there's a lot of paperwork when it comes to that. So typically also companies didn't have more than one fax machine. And the fax machine was kind of like in the reception area, right? Or where the personal assistant person or whatever is working. And so people can go in and out, and then people would fax their information there. We want to make sure everyone who works there is trained to respect the privacy of their clients, right? So this is why that is happening. Okay, protecting a client's health information, and most social services agencies must adhere to these rules. And if you break it, you could be fined from $100,000 to $250,000, and also be in prison for 1 to 10 years. This covers, so we're talking about the privacy of case management, care coordination, formal records, personal notes, and of course, billing information. So these are things that we want to make sure that it maintains privacy. All right, disclosure. Information is released, transferred, or divulged outside of the agency. So what that is talking about when it comes to disclosure is you're telling people outside of the working relationship about information about the client. The Protected Health Information, or PHI, patient files access to people not working for the agency. So other people who are requesting the information, you're able to disclose it per the permission of your clients through written formats. Okay. All right, agency requirements. Comply with HIPAA. Agencies must have number one, statement of the agency's privacy and confidentiality procedures as it relates to releasing patient information. Must be given to every client of the agency. How health information will be disclosed and stipulating the client's privacy rights. So every time you go to a hospital, every time you go to an agency, like a counseling agency, you know how they make you fill out all those paperwork at the beginning before you do anything? That is because they're protecting themselves and saying, like, we give you all these things so you know what your rights are. Okay, so it's really important for you all to look at all that stuff. Don't just sign it away. Because if you do something or they do something, you're like, wait a minute, I didn't approve of it. Yes, you did, potentially, when you signed all that paperwork, right? And usually they'll give you a copy of everything so that you can review it later on if you want to as well. Okay, number two, form that people sign and return to the agency indicating that they have received a statement on confidentiality policies, like we just said. Three, privacy officer who is familiar with HIPAA requirements and can oversee implementation within the agency and resolve privacy issues. So typically, there's a person at every place that you can talk to. Sometimes they're known as an ombudsman, right? Sometimes it's someone in HR, human resources, who can help you with that stuff. You should always ask for their contact info if you want to, so that you can talk to them later. 4, set of safeguards to protect client records. So that means talking about where is it all this information being stored and stuff like that. All right, oral communication. Make reasonable efforts to safeguard client information. So this one is kind of like, don't do office gossip, right? Do not talk about clients where others can hear. Avoid situations with clients where there is no privacy, and lowering your voice when discussing clients with others in the agency. So basically, kind of like, don't talk out loud, with your coworkers about clients out loud, okay? Because if other people could hear and identify, you have now broken a lot of rules. Okay, now let's talk about telehealth communication. Agency must provide a secure online connection and encryption, which are HIPAA compliant. So again, HIPAA has many rules and expectations, and it should follow those rules and expectations. Using your home computer without protections where other people might have access to your computer is unethical. So let's say, for example, there is a password. There should be an account for your work only, and that's it, and no one in your family should be able to access that account, right? Or you might just have a work laptop where you only do all your work in that laptop and that is it. Your personal stuff is on your own computer. That way you're not mixing the two, which is probably the best way to approach this. You must have a HIPAA compliant platform and network. And typically if it's an agency that you work with and they provide a laptop or a phone, usually they're on a safer platform and network. So you want to just keep all that stuff with your work stuff and then it's it. Don't mix private and business together. Using technology in certain ways can also create an impression that a relationship differs from the original intention. So emojis, right? It might make you look like you are a friend of your client. So when texting time and place to meet, and that's it. You should only talk about those things. You don't want to have a conversation, right? And if agency provides caseworkers with a work phone, it is probably encrypted. So again, that might be more preferred. I know that you all like to send out emojis and stuff like that. I tried to avoid doing that. I just kind of am straightforward with my text messages when it's professional. Okay. And I hope and encourage you all to also do the same thing as well, just in case we want to avoid misunderstandings with your client. So let's talk about the HIPAA requirements for release of information forms. So in plain, understandable language, signed and dated form, you and your client. Description of the information to be used. So what is the information that we're going to basically release, right? What is the topic or the area that we're talking about specifically? Name the recipients of this information. So who are you sending it to? Okay. Their full name, their agency. Those who disclose the information, so you, if you're the caseworker or the agency, must be named also on that form so that we know who's responsible. There's an expiration date. So basically, in 4 months, this is no longer considered valid. If they need it for something, they need to do another request. Okay. Statement describing the purpose for releasing the information. So probably something where the client says that I need to release this to receive services or benefits or something like that, let's say. Instructions telling the client how to revoke the form. So you also need to let the client know, hey, if they change their mind, let us know by filling out this form, okay, or to reach a specific person. Indicate that the information may not be protected once it is released. So let them know once it leaves our agency, our, let's say, our protection encryption, we can no longer guarantee that this is going to be private. If the other side decides to release it, it's no longer our fault. Okay. If the agency will receive money for the information, so such thing as insurance company. So again, if you're doing this to an insurance company, there's going to be potentially money involved, right? So let them know that. And make clear that the client's rights for a copy of the authorization that they have signed. So you want to give them a copy of everything too, so that they can't say, I didn't sign anything. You're like, nope, here it is. And we also give you a copy as well. All right, individually identifiable health information, demographic information such as age, gender, income, and race. You have to be careful with those things because people could still potentially identify you. Clients may make a written request for information to be restricted. So that means that they can say, you cannot share any of this information with my family or my friends. You cannot send me anything in the mail to my house. And you cannot call me on my home number. Okay, so if they do that, you have to respect their request and not do those things. Obviously, you're going to have to talk to them about alternatives if they're trying to reach them, maybe as an email or something like that, right? So you got to make sure that everyone is aware of what's going on. Accessing the files. Clients have the right to read their files, make copies of their records, and make corrections or additions to their files as long as the changes are accurate. So this is really important, is that when you write your case notes, it should be in a very specific format, depending on where you work. It could be what's known as a SOAP note. It could be a GURP note or a DAP note. Those are the three probably most popular ones. So you have to learn how to do those, and then from there, write it in there. Because if you just write free form paragraphs upon paragraphs of your case notes, that's not going to cut it. And it might cause confusion when other people read it. There is a way to do all of those types of documentation. Must be presented in writing to the agency. State the reason for amending the records if the client decides to amend it. And guardians also have a right to access this information if they are under guardianship, like they're a child or they are someone who's not able to make their own decisions. Social media. Many ethical codes have not caught up with social networking. Some agencies forbid all use of social media due to potential for HIPAA violations. If your agency does not have guidelines, it does not excuse you or others from exercising sound judgment. So the bottom line is never post anything about your work on your social media. Okay, so the first thing that's talking about is that a lot of ethical codes do not have it or is not caught up, because I would say most code of ethics are revised every 10 years or so. But think about all the different social medias that have existed within those 10 years and what has changed, what is still being used and what is not being used. All those things keep on changing, right? So we are a little behind when it comes to that. So it kind of looks messy because of it. But this is how, we have all settled and realized that this is how it's working or how it's happening. Privileged communication is a legal concept. It protects the right of the person to withhold information in a court proceeding. So privileged communication is a legal term, okay? It is a right that belongs exclusively to the client. It does not belong to the worker or the agency. So let's think about this, okay? So the client is going to court, right? And then you are being asked to go there to tell them about, tell the court about what is being talked about within your sessions. You can say privilege of communication, so we cannot disclose anything. But if the client decides that they want you to share, then they can sign the paperwork, so that is released. Okay, so protect the client from the disclosure of confidential information during a court proceeding. If the client waives their right to privileged communication, then the agency must share that information, because now it's no longer something where you can say, no, we still don't want to share. You now will most likely have to share that information. Okay, this is once a client decides. Oftentimes this is doing with divorce, maybe about custody of children, or domestic violence are common topics when it comes to going to courts and talking to therapy or therapist about what's going on in the court setting. All right, legal proceedings. You are acting in the court-appointed capacity, such as a guardian or a payee. So these are times where you are able to release information because you are actually someone who's been appointed and you need to talk about the well-being of your child, or that child anyways. You or your agency is sued for malpractice. So let's say if your client sues you, you can now talk about certain things that happened during that time period, why you do not think that you're guilty of malpractice. And in that time period, you might have to reveal certain things, right? The court mandates that you turn over certain information. So sometimes, even if you say privileged communication, the courts can say overturn. We still need to know what's going on. So again, it depends on the situation of that court lawsuit or whatever it is. The client uses a mental condition as a defense or as a claim in a civil action, or basically goes known as an insanity defense, right? So that's saying is that they are not able to think properly. So if they're saying that, that means that there needs to be a professional, mental health professional, that can vouch that this person is not able to make their decisions to the best of their knowledge, or the abilities of their knowledge. Protecting clients and others from harm. So when you believe that the person has suicidal intentions, you can then, of course, release information. When a child is under 16 and is believed to be a victim of a crime, such as a sexual or physical abuse or sexual exploitation, when you determine that the person needs to be hospitalized for a mental condition, or when the person has told you of their intention to commit a crime, harm another person or themselves, then you will have the right to reveal this information to other people. This will be mentioned in their informed consent, so that they know that if they say something like that, that you are obligated to report them. Okay, a very famous lawsuit happened called the Tarasov decision. There's a person named Prosenjit Podar, who is a student at, I believe, UC Berkeley, and he told his therapist that he intended to kill Tatiana Tarasov. So Dr. Moore contacted the campus police at UC Berkeley, who detained Podar and released him since he seemed to be rational after interviewing him. Okay, so what happened was the doctor, or the psychologist, reported that this person said he wanted to kill Tatiana Tarasov. The police, the campus police, did an interview with them, but released him because he sounded totally fine, right? And then Dr. Powelson, which is Dr. Moore's supervisor, said to Moore that you don't need to do anything else since, that was addressed already with the police and stuff like that. But because no one warned Tatiana Tarasov, she was, I think, on vacation, and when she came back, Podar killed her. Okay, so there was a major lawsuit, and now that lawsuit, the Tarasov decision, is known as duty to protect or duty to warn, which basically is saying is that we must warn the intended victim. We must also warn other people who are close to them about the victim being in danger, like let's say their parents or their family members, and then also warn the police as well. Okay, and so that's a very serious major law. Please be aware of this law. There's also the red flag laws. Laws in some states that require removal of guns from a person deemed to be a danger to themselves or other people. So there might be because of involuntary commitment to a mental health facility, that automatically does a red flag law report, which is sent to the state police so that they're aware immediately. Some states, only when a person is reported by someone, the police, health professional, or family member, will it be included. So this is also in domestic violence situations as well. And in California, if you are interested, I put a link there for you to look at for specifically California. All right, mandated reporting. All states have laws that require professionals to report abuse and neglect of children, and for some states, older adults. As a social service professional, you do not have the choice about whether or not to report. You have to report if you suspect that there is abuse. Sometimes professionals feel that making a report will ruin the relationship between them and the client, which is potentially true and definitely possible. Some do not feel that they have enough proof, which is why they don't do it. However, typically you will have to do it. And you can also consult your supervisor, person at the place as well when you do the report. Usually you do it all within the same amount of time or the same time range. The agency that you're going to report to is called Child Protective Services. I believe in Los Angeles, it's called DCSF. They will make the ultimate decision about it there if there is any abuse. So, for example, I have actually had to call Child Protective Services for a client of mine. And so I told them exactly what the situation, what did we talk about specifically? And then they said, you know what, this doesn't really sound like child abuse, but thank you so much for reporting, so that they have it, right? Older adults, they might be victims of physical, financial, sexual, or psychological abuse. You know, you think about older adults who might have a lot of money. They've been working really hard, and now they have all this money in the bank account, and someone might actually try to steal all their money, right? So this is also a very common, unfortunate population that gets abused. Involuntary commitment. So this is when a client is placed in a facility that specializes in inpatient mental health care. So they are placed there because of some signs, either by their caseworker, their therapist, or some other professional. Okay, clients have a right to the least restrictive form of treatment. Still, obviously, they're not supposed to be just locked up. If they do not need a locked ward, they should not be locked up. If they can get care that they need in a partial hospitalization program, then they should not be going to a hospital either. So again, they still have a lot of rights, but there is a moment where other people might come there or come and get the person just to make sure that they do not hurt themselves or other people. A person who poses a danger to themselves or to others, and then one or more of the following as well, which is number one, has a severe mental illness or one that is happening at the moment. It's acute. So acute basically means it's happening right now, but it's not always there every day or whatever. It just may be under a specific amount of stress because of work or school or whatever, and then it triggers it. Number two, unable to function in occupational, social, or personal areas, cannot provide adequate self-care. 3, refuse to sign a voluntary commitment to treatment or incapable of signing such a commitment or choosing appropriate treatment. 4, can be treated once committed. Medication and or treatment can relieve the acute condition that they are feeling at that moment. And 5, commitment adheres to the criteria of the least restrictive treatment setting. Obviously, there's a lot of conversations when you think about celebrities who are like this. Britney Spears is probably one of the most famous when it comes to involuntary commitment. And the reason why it's not because she shaved her head, because people can shave their heads if they want to. It was because she locked herself in the bathroom with her 2 kids and refused to leave. And so people thought maybe there might be harm to her kids, which then sets off something where they're able to then, involuntarily commit her. Okay. Amanda Bynes is another major celebrity who also had something similar. Well, not the same situation, but was also called into a 5150 to make sure that she is not going to harm herself or other people. Obviously, we'll have more of a conversation with that in class if you all want. Okay, this is the end of the chapter. Bye.